Doug Rohan returns to the Big Mountain to talk FSU versus the ACC.
The ACC lawsuits are always in the news, so we're back on the Big Mountain with a very special guest.
Hey, good to have you here on the mountain again. I am JY, and this is my good friend Steve. And you can all see we have Doug Rohan back on the channel again. Really happy to have him on. We have some questions we want to talk to him about, especially regarding this second amended complaint. And I do have a question about AG Moody that we're going to get to at the end. I'm confused about what she's doing, and Doug is going to send me straight. So Doug, welcome to the show again. Really glad you could be on with us.
Thank you guys for having me back. It's always a pleasure. Really enjoyed your shows.
Yeah, and Doug, again, we appreciate you. I know you're a busy guy. So for anybody who's watching our show, if you are following the ACC lawsuits and you're interested in the fate of Florida State, whether they're going to be in the ACC, in the Big Ten, how much it's going to cost, you got to be following. It's at Rohan Law on Twitter.
PC, yep.
Yes.
Rohan Law PC.
Yeah, you got to be following him. And then obviously, if you're in the in Atlanta area and you have and you need a lawyer, go to Doug for sure.
Well, let's jump in if you're ready to rock and roll here. We got some
Let's
beefy.
do it.
We're going to do some beefy questions. At least we think they're beefy. I don't know if Doug does. But anyway, so the first one I want to talk about is this new count one that they have in their amended complaint. And we did a preview or summary episode on this new filing that they did in Leon County. And really that real first paragraph, after the first paragraph, just, hey, we're the plaintiffs and defendants, blah, blah, blah. But the first real introductory paragraph, they went right at it. They said the two main topics, this being one of them, and count one says the grant of rights never transferred the media rights for FSU's home games after FSU leaves the ACC. So that's why I want to start with you here, Doug. My question is, and my understanding, I think, is, doesn't the ACC have the rights to these games for the duration of the grant of rights to broadcast them wherever they want, however they want, or potentially, I guess, not broadcast them, as long as considerations being given, as long as FSU is being paid under that agreement? I know that's probably kind of out there to hear me say, well, they don't have to broadcast these games. So I am taking a big jump here, but I'm doing that just so I can understand, how does this work with the grant of rights? Because to me, they're saying, yes, we're giving you our rights, our media rights, and you can make them on ESPN or wherever you want, as long as we're getting the money, the correct consideration for them. So where am I going wrong here?
Well, you're going wrong with believing what we were told for the last 10 years in the headlines of stories. And the headlines of stories say, this is the grant of rights. The grant of rights is irrevocable, and Florida State is granting all of its rights to the ACC. The problem is that ignores general ideas of punctuation and words and their meanings. And that's why we have this entire industry dedicated to contract law and interpreting contracts. The grant of rights sets out in paragraph 1 that each member of the institution hereby irrevocably, admittedly, that's irrevocable, and exclusively, solely for, this is the only purpose for, grants the conference, here the ACC, during the term as defined below. So everything that you have said is correct up to that point. All rights are granted irrevocably to the conference for the term as defined below. But what is all rights? All rights are the rights necessary for the conference to perform the contractual obligations of the conference expressly set forth in the ESPN agreement. That's where the comma comes in. The rest says regardless of whether the member institution remains. And that's where the idea that this is for the term of the agreement. But the only rights, the limited rights that are given up, are those rights necessary for the conference to perform the contractual obligations as set forth by ESPN. So there's two issues there that are new in this new count one. The first of which is, what does the ESPN agreement say? We don't know. That's what Clemson's about to get. That's what we've been told about. But Clemson attorneys and Florida State attorneys have seen the agreement, and in their allegations, which it is Florida State's interpretation, but anytime you put allegations in these counts in front of the court, what you're saying is, this is what we think we can prove. And what they're saying they think they can prove is that ESPN agreement only allows ESPN to broadcast ACC member games. It doesn't say FSU games. It doesn't list the 15 members of the conference that are included. It just says ACC members. Well, when a member announces its departure from the league, it is no longer a member of that conference. So that's where they're getting this language from.
Makes complete sense. And you were very kind to me, because you could have just said, because you're drinking the blue ACC Kool-Aid, JY, that's why you think the way you think. But that makes total sense. And I want to, I have a follow-up question that I think you've somewhat already answered.
There should be some.
Yeah.
I would be concerned if you didn't have follow-up questions today.
Okay. But you said something that I had said on a previous episode, and I still think there's people that are confused that no one has seen the ESPN media rights agreement. And I made a comment several weeks ago where I said, no, they've seen it. They just don't have a copy of it. And we had a few commenters be like, are you sure that they've seen that? How do you know that they've seen it? I'm like, they've told everybody, you can fly or drive to the ACC headquarters, and you got to go to the secret spot with the cameras and the or
you can take notes, but
you can take notes, but you can't take pictures of it, and everybody's watching you and all that kind of stuff. So, I mean, that's your understanding, correct? Like, they've always had access to the document. They just don't have physical access to the document within their universities. Is that basically the correct understanding?
I was present for the first Mecklenburg hearing, and that's what the attorneys for both the ACC and Florida State were expressing, that the documents, the contracts, plural, were available and were made available for inspection. But to your point, they were observed while they were doing it. They couldn't take pictures. They couldn't take written notes. They just had the opportunity to read it. And that's where, some people are talking about how is it this clear and this obvious? Look, it's taken me 4 months to get to this point. I was on the idea of it being skeptical from the beginning. But in contract law, when you read a sentence and you reread a sentence and you read a sentence for a third time, and then you start thinking about it from a different perspective, that's when you see the different interpretations. And yes, they are different interpretations of the same words, but you focus on different aspects. So when you heard irrevocable, when you heard for the term is outlined below, that's what we initially were focusing on without realizing what we intended to do. And let me be very clear. The intention of the ACC was absolutely to have all the rights from the beginning for the duration. But the problem was they copied somebody else's homework. They got lazy. They got sloppy. They changed the one sentence that could have done what they wanted to do. And that was to explain that this agreement, unlike the Big 12 grant of rights, only applies to ESPN.
The other big thing they left out, as we've talked about before, is it the choice of law? Is that the correct one? Or choice of venue? Like, that would have helped us in this situation right now too. But that wasn't a question we were going to talk about. But it seems like they've left out a couple of really important pieces to these documents. But I want to get to my follow-up. So if what we know and what you've kind of said about the media rights agreement is true, and that the ACC, what we've heard is they have to have 15 members in order to have a full conference for their media rights agreements, and they don't, to our knowledge, name the universities of who they need to be, but they just have to have a minimum number of universities. To me, if that's the case, then with the additions of the 3 new schools that they're adding, Cal, Stanford, and SMU, a withdrawal of, in this case, FSU and maybe even Clemson, it's almost irrelevant because they're meeting the threshold that we know of within the ESPN agreement. Is that a step too far, or am I missing something there as well?
No, you've hit the nail on the head. And that's part of what's making this such a fun exercise. This is going to be on bar exams and final exams in law school for years to come, because you have what you're talking about, the composition clause. The composition of the ACC must be at least 15 members. So you bring in 3 other members. Florida State and Clemson are making the argument then, if we leave, what are we talking about? Liquidated damages. If we leave the conference, we're not hindering the ACC from continuing their ESPN agreement. They are still having the 15 members. So we're not in trouble. Now, it's the two biggest schools, it's the two highest branded names within the ACC. So it's disingenuous to say there's no economic impact, but we're not ruining the party. We're not peeing in the cornflakes. We're not making it such that ESPN suddenly blows up the entire deal. Now, they might on this look-in provision, we'll talk about that in a moment also.
Right.
But as far as the composition clause, there is no damage to your point.
Okay. All right. Yeah, and that's huge. I mean, the composition, of course, is meaningful. But if they're trying to make sure they're going to be showing a certain number of games, 7 games a week, as an example, do the teams technically matter, or is it just that, hey, we know we're giving you 7 games that you're going to be broadcasting every week for the duration of the college football season? The value could change because of the composition, but it certainly doesn't blow up the agreement, I wouldn't think. So.
And let me add to this point also as a secondary issue. This is part of the reason why Clemson and ESPN feel comfortable undercutting the ACC's argument, because if the concern was how many members' rights you can broadcast, then under the ACC's interpretation, if Florida State and Clemson left, they would still have their rights to broadcast.
Yes.
So if that were the case, why do you need to add 3 more new members? Why do you need to worry about the composition clause? The day the grant of rights was signed, there were 15 members. Until 2036, ACC, according to your logic, you still have 15 members regardless of what those institutions do. And that the courts don't like language that doesn't make sense.
Well, that makes sense.
Yeah.
So I'm going to turn it over to Steve. He's going to talk. Maybe you have some follow-ups, but I know you got to talk about your favoriteest item in the entire situation we have ongoing here.
So Doug, before I get to my questions, I have a follow-up on that. So if we're talking about the composition of the conference, and if 15 is the number, didn't the other schools that are suing Florida State and now Clemson, didn't they shoot themselves in the foot by adding these schools? They're basically if that's the standard, if the contractual obligation is to have 15 schools, didn't they kind of sow their own seeds of destruction there by adding those 3 schools?
Look, my mom always taught me never to interpret malice where incompetence is a sufficient explanation. And that's effectively what is happening here is the ACC thought they were doing A. What they thought they were doing was overcoming the risk of 7 members blowing up the conference altogether. That was their big concern. We had the Magnificent 7, as Pete Thamel had mentioned last year at the ACC conference. And there legitimately was a perspective from 7 members who at least were talking about this, that the best bet was just to dissolve the ACC. So they scrambled to find any warm bodies. Don't get it wrong. These are not 3 premier eyeball drawing programs that the ACC coveted to add. They might covet UConn. They might covet USF. They just saw 3 warm bodies available. They needed to get that number high enough that the Magnificent 7 were impotent and couldn't do what they wanted to do. But to your point, in doing that, they undid one of the features they had in their agreement to prevent Florida State and Clemson from escaping.
Well, my grandma had a saying, don't cut off your nose to spite your face. And it seems like this is what they might have done. Okay. So, which to me is just shocking. If that is the final outcome, that basically, that they own their grant of rights only so far as to maintain 15 teams to fulfill their obligation. If that's what lets Florida State and Clemson and someone else out the door almost scot-free, that's just unbelievable level of incompetence that, and we can start making our comparisons to the Pac. So far we've said, hey, the ACC was a lot smarter than the Pac, but maybe they weren't all along. So, okay. So moving forward, I have the topic that I've been on since the very beginning. JY will tell you, very beginning of this case is the sovereign immunity question. Okay, I'm a big, I won't say fan, but I'm very interested in just constitutional issues, different matters between different states and things. So Before we get that far, I'm just going to say here, I want to ask you a pretty simple question. So do you believe that the Florida State Board of Trustees is in fact a sovereign entity in the state of Florida? And if so, is Florida State correct in saying that the Florida State Board of Trustees would have to expressly waive sovereign immunity? And I emphasize expressly because it seems like there's a big difference there. Judge Cooper, he talked about express or
Implied.
versus implied. And Judge Bledsoe down in Mecklenburg County, in North Carolina, he kind of just glazed over that and said, "Hey, they're operating here. They that is an implied waiver of their sovereign immunity." I mean, that's obviously kind of painting that in simple strokes. But in your opinion, does Florida State have a case here? Can they claim that the Board of Trustees is its own sovereign entity in the state of Florida and would have to expressly waive that sovereign immunity?
Steve, you've written probably one of the best state con law final exam questions that any FSU or Florida grad is going to be looking at again for the next 2 years. But you phrased it ideally, and it really was perfectly stated. The Board of Trustees is the governing body for the state university member. The state university member is a member institution of the larger state university system, which is a sovereign because it is acting as an offshoot of the state of Florida. So in my interpretation, the Board of Trustees is a sovereign within the meaning of the Florida Sovereign Immunity Statute. The statute is what says any waiver of sovereign immunity must be expressly stated. And I would have to wonder where specifically that expression would have to be stated. I don't believe every Board of Trustee approved contract necessarily has to state that. There just needs to be something in the charter, in the grant of in the university charter that says we expressly waive our sovereign immunity within the state of Florida, or when it comes to litigation. The problem we have here is the interpretation between express and implied and the jurisdiction North Carolina versus Florida. Bledsoe is alleging that an implied waiver by acting in concert with the subject as laid out in the Troy University case is sufficient to create an implied waiver of North Carolina to the jurisdiction of North Carolina. The Florida State Board of Trustees and attorneys are arguing there is an express waiver of Florida sovereign immunity in Florida, but only in Florida. So that's where, and to get to peek ahead to your follow-up question, I don't know if this is going to the Supreme Court or not, but we have a conflict, and one of the parties is a sovereign state. And if you look at what the basis is for any Supreme Court action, Article 3, Section 2, Clause 2, in all cases affecting ambassadors, no ambassadors here, other public ministers and consuls, that doesn't apply, and those in which a state shall be a party, not two states, but where a state shall be a party, the Supreme Court shall have original jurisdiction. So I go back to what I said on your last show and what I've said a couple times on Twitter. This, whether or not it is a Supreme Court case or not, I don't know. It would seem there is a potential, an avenue, but you also have to compare that to the 150 Supreme Court writs that are granted, in contrast to the 7,000 applications for writs, where 6,850 are denied.
Right.
So could there be a writ to the Supreme Court? Certainly possible. Is it going to be granted? Very unlikely. The Supreme Court would have to agree that this is such an important issue that may come up again in the future that we have to take a look at it. And I don't know that we rise to that level.
Yeah. Okay. So I have a couple follow-ups there, Doug. Okay.
Let's go. Unpack it.
All right. So Farmer versus Troy is the case that was cited in Judge Bledsoe's court as the precedent there, where I think it was Troy University from the state of Alabama.
Mhm.
They're a state school, and so they're a public school in the state of Alabama. They came into North Carolina and they established some kind of a business. They established whether it was fundraising or recruiting to get students, they established some kind of business. I just want your opinion on this. To me, that doesn't really seem like a very good example or precedent, because it seems very different from what Florida State is doing in participating in the ACC. They didn't come in, they didn't get a business license, they didn't set up a storefront. They're not soliciting for, as far as I know, they're not soliciting for donations or setting up a recruiting, an office to get to, a satellite campus of Florida State at, at Wake Forest or anything like that. So what's your opinion on that, as far as that being the precedent case, that Farmer versus Troy?
I was, of all the things that Judge Bledsoe said, I was most shocked and disappointed in this particular point. And that is because, as you described, as you stated, Troy, as a public University of Alabama, came into North Carolina, opened an office. To me, the most important part was they actually registered with the Secretary of State, which means they have a registered agent. One of the principal jobs of a registered agent is to receive lawsuits, summons for lawsuits. So they open an office, as you said, but within that office was somebody whose job was to receive lawsuits. They knew by opening and going through this process, they were opening themselves to being sued in North Carolina. There's an acknowledgement there. Judge Bledsoe says, I'm going to interpret Troy case to say it's not a requirement that you open an office and get a registered agent. That's just an example of Troy University doing business. So on a scale from 1 to 10, Troy University did a 9 in terms of business being done in North Carolina. Florida State invites students to apply from North Carolina. They do make money. Sure. Florida State comes to North Carolina to participate in championship games. Florida State comes to North Carolina to have board meetings. That might only be a 4 on the scale from 1 to 10, but it is on the scale. And because it's somewhere on the scale, I'm going to interpret it to say that meets the requirements. And that is where going to the Court of Appeals or the Supreme Court of the North Carolina, that's what they're asking in their petition for the Supreme Court to say, no, that Troy case actually laid out a substantially different set of facts than what is happening here with Florida State.
Yeah, that makes a lot of sense. That really clarifies for me, because I was just having a hard time understanding how that was the precedent when it seems so different.
Well, Doug took the words out of JY's mouth.
Yeah,
because I was going to say some of what he just said there, in that, they have activities. I'm sure they're getting scholarships and
Student applications.
Thank you, not scholarships, applications and things like that. And it's a definitional issue.
Right.
And I like the way you laid it out there: a 9 versus a 4 versus a 5 versus a 1. As long as it meets the definition, it might not be as strong of a business relationship, but it's still some sort of a business relationship. So that was perfectly eloquently said there, Doug. We wouldn't have expected anything else, but I thought I was going to have to be ACC JY. I didn't have to. Doug did it for me.
He did a great job of explaining, because I kept coming to that thinking this doesn't make a lot of sense why they're comparing the two, and it makes sense that there's somewhat of a comparison there, but not to the full extent.
Yeah.
Okay, so I have one last follow-up question. I'm not going to try and pin you down on the Supreme Court thing. Last time we talked, you felt pretty certain that it would not go the federal route and end up in the Supreme Court. You talked about the good faith and credit clause, that each state had to respect the decisions in the other state, especially if one state came to a decision first, if there was a final verdict or judgment. You talked about that a little bit. But now you just mentioned I forget what you called it, but the other clause where if there is a matter between two states, that the Supreme Court has original jurisdiction. So I want to give you just a hypothetical, and I'm not trying to pin you down. You don't need to give me a definitive answer. I just kind of like to hear just a little bit of an open response from you on this scenario. So if let's say there's not a settlement and we go down this route all the way to the end, similar time frames, because there's like one train pulls ahead, the other train pulls ahead, we have a delay in either court, but similar time frames. And in North Carolina, let's say we get a judgment in favor of the ACC, and then let's say in Florida we get relatively around the same time, we get a judgment where in favor of sovereign immunity, in favor of Florida State being a sovereign entity, and there's a conflict, basically some sort of conflict in the rulings, whether it comes down to sovereign immunity or another factor. Where do you see us going? Do you see that as still just a simple matter of the good faith and credit that the state of Florida would back off and say, well, North Carolina decided it? Or could we see a scenario where a judge in the state of Florida, or perhaps the attorney general or the governor, says, no, we have a judgment here in the state of Florida. We don't believe that the law was interpreted correctly in North Carolina, and that decision in North Carolina is not going to be enforced here in the state of Florida. Do you see that as a possibility where we have real competing judgments? And if so, what are we looking at then? Like you mentioned, it's not every case is heard by the Supreme Court. It's a small percentage of them. I kind of think that would be kind of a new unprecedented case with the big business of sports, billion-dollar industries, that maybe the Supreme Court would want to get involved. They've gotten involved in these NCAA lawsuits. But I just want to hear kind of just an open response from you on that scenario. I know I gave you a lot of hypotheticals there.
That's all right. You want my thought process. You want some indication of what the issues are. Let's back out for just a second and show a clear example of what we mean by the full faith and credit clause. In my state of Georgia, you have to be 21 to drink. In Louisiana, you have to be 18 to drink. If a Louisiana resident comes to Georgia, Louisiana resident can't buy beer. Louisiana resident can't say, well, my state, I only have to be 18. The state of Georgia applies. Likewise, if my daughter, who just turned 18, goes to Louisiana, she's going to have a great time, and I have to trust her to make good choices. The state is able to have their own rules, their own laws. And similarly, what we've seen in some of these civil rights cases and in some of these abortion cases, not to get too political, but whatever the ruling is in Texas applies to Texas residents, and whatever the ruling is in Wyoming applies to Wyoming residents, even if those are two different opinions and two different set of facts. The problem we have here, and we talked about this originally because we were following David McKenzie down this path of the full faith and credit clause. If we get to an ultimate judgment, ultimate decision post-appeal, whatever court finishes first, it does have to be respected by the other court, by the other state. But I'm starting to see some significant obstacles and roadblocks that tell me we're never going to get to a point where we're actually having two cases go that far down the rails. And the reason why is because of what we're talking about right now with the sovereign immunity issue. That is a procedural issue that has to be established as a foundation to these cases proceeding. So if we get a year from now and there's no settlement, and North Carolina has concluded, based on the Supreme Court of North Carolina, that sovereign immunity doesn't apply, and the Court of Appeals in Florida has concluded that sovereign immunity does apply, that's where the conflict involving not two states, involving a state agency, the Board of Trustees, and the ACC. So that was the second part of why I thought previously there was a problem, because it didn't involve two states. This is involving the state of Florida and the ACC. Now, rereading the clause in the Constitution, it's just a controversy involving a state. So I would expect that if we don't have the North Carolina Supreme Court agreeing that this should be in Florida, and if we don't have Florida saying, no, North Carolina was first, you need to go play in the sandlot of North Carolina, then I believe there is a foundational issue that has to be resolved at the federal level. And that, to your point, then, the Supreme Court, when they deny cert, what they're saying 9 times out of 10 is, we believe the lower court was correct. Well, there is no lower federal court. Two competing state courts saying two different things. So to your point, Steve, it may be that the Supreme Court says this is something we need to resolve because this is a new up and coming issue. What's the percentage of that happening? Less than 5% chance. 95% chance we reach a settlement long before that happens.
It'd be fun though.
Oh yeah. Hey, we'll be, if that happens, Doug. Okay, we need you. We need you to go to Washington and be our man. You'll be the man of the people out there on the front steps of the Supreme Court, reading that ruling. You know, just like Bush v. Gore so many years ago.
Yep, I will do that for you all.
Well, I say it's fun because we don't have skin in the game.
Yeah.
Doug has skin in the game, so maybe not quite as much fun. So before I get to the final item with AG Moody and the writ of mandamus, I do want to get back to something you commented on in my first question. And Steve and I have a bit of a disagreement here. And I want to see, maybe you can set up one of us straight. And that is this whole opt-out versus look-in situation with ESPN. So forever, it seems like, at least FSU was saying, this is an opt-out, this is an opt-out, this is an opt-out. All of a sudden now we're hearing this look-in clause. To me, there is a substantial difference between those two things. Steve disagrees and says it doesn't really matter. I don't want to put words in your
mouth. Well, what I said, you're saying that there's a definite distinct difference between a look-in and an opt-out. What I'm saying is the look-in could be open-ended. They could opt out, they could ask to change the terms. There could be, for a look-in, unless we know the exact language, it could be a lot of different things.
Okay, so here's I'll give you the definitions so that's Steve's definition. JY's definition is a look-in is just a look-in, and they can't opt out. They're just looking in to maybe see who the new members are because we lost FSU and Clemson, and now we've got Cal and Stanford, and do they rise to the same media value and all that kind of stuff. So I'll make the distinction where Steve is saying a look-in could have an opt-out, where I'm saying a look-in, it's just a look-in, you're still under contract. What says Doug Rohan?
Steve's right, sort of.
He's always
well,
right.
To your point, JY, if what you're describing is the situation, it's just the status quo. That's just the contract.
Yeah.
The look-in provision is a legal option, and we'll talk about that in a minute, versus the option to extend. So the way I like to differentiate the two is one is passive and one is active. What I mean by that is a look-in provision means, according to Jim Phillips, who has recently started talking in these terms,
yes,
is the ACC has the chance to look in and decide, do they want to renegotiate? Do they want to extend, or do they want to extinguish? They have three options.
Okay.
But if they don't do anything, then pursuant to Jim Phillips, the contract is through 2036.
Okay.
So that is a thing. It's an unusual thing. Why would you need to have a fixed window by which to renegotiate a contract? And I don't practice entertainment law. I'd love to, talk to one of my friends and get their perspective. It doesn't seem typical in contract terms. Okay. What is typical in contract terms is a unilateral extension, which is what Florida State alleged in their complaint. The allegation was the ACC agreement with ESPN only goes through 2027, but by February of 2025, the ACC unilaterally has the right to extend that to 2036 without any further negotiations. That is typical in some of these contracts. I have that with my leasing office, leasing space for my office. If I want to extend, I just say, check the box and say, I want to extend. No more negotiating, no more terms. There's an escalation clause. Right. It goes up by 4.5% already on an annual basis. So one of those things makes sense and is common. One of those is highly unusual. Okay. Now, to that end, ESPN got very upset when Florida State disclosed something in their contract agreement. Yeah. And it wasn't mentioned in North Carolina, Mecklenburg County Courthouse what was disclosed that upset ESPN. But if you compare the two, complaints and the two agreements and what was shared in ACC versus Florida State and Mecklenburg and what was shared in Florida State versus ACC in Tallahassee, there's really only one paragraph that was only in one lawsuit. And that was regarding this option, and a unilateral option without any additional consideration. So to go back to your earlier theme and concept, it does seem like the ACC keeps tripping over itself and doing dumb things, and they're going to reap the benefits of those poor choices.
Yeah.
So just to clarify, when you say unilateral, you're saying one party would have the option, and are you saying that would
Correct.
be the ACC or would be ESPN?
ESPN. If ESPN does nothing, the ESPN ACC agreement ends in 2027. If ESPN affirmatively chooses to extend the agreement at a 4.5% annual escalation, it can go up to 2036.
So then the commissioners being a little
cagey.
Thank you.
and we saw that with Commissioner K out with the Pac-12 when they were trying to get a deal before that whole thing fell apart.
Yeah.
And that's what commissioners are, somewhat cheerleaders. They're out there to put the best face on for the conference and to appear as strong as possible so that they're in the strongest possible negotiating position. So he's doing his job.
Commissioner Phillips said at the ACC meetings, there's just one or two things that need to be looked into. Those one or two things are whether or not ESPN is going to continue this agreement past 2027.
Yeah.
Pretty big thing.
Not lying.
One or two things. All right, let's get to the writ of mandamus. When we did this episode, I looked at this, I went, I don't quite understand why she's using this, she being AG Moody here. This looks like it's for, and this is a very simple layman man's, Google search as to what one of these suckers is, but it doesn't seem like it really applies to what she's trying to get at, which is the actual agreement, making it open to the public through public records acts and things like that. Whereas a writ of mandamus is more, kind of slapping somebody's hands that's at a lower level in the government and saying, hey, you didn't do what you're supposed to, you got to do it. So what am I missing on this? Why is she using this to try to get at the media rights agreement? Can you help me understand this? Because it just doesn't seem like it fits for me here.
A writ of mandamus is appropriate to be used to compel the release of records after a public records request was made. Traditionally, and the generic definition of a writ of mandamus is to file a writ of mandamus in the appellate court to tell the lower court they need to do X administrative job that they're supposed to do. Firearms license, ruling on a motion. I've had motions that sat on judges' desks for 6 months waiting on a ruling. You can go to the Court of Appeals and say, we've given up. Would you please tell this judge that they need to rule on this motion in the next 10 days? So that is the traditional sense. But a writ of mandamus can be used at the district court level here in Leon County to compel another individual to comply with a very clear administrative order. So in this case, AG Moody issued the request to the ACC for the public records, to ESPN for the public records. They failed to act. So now the writ of mandamus goes to the lower court to compel the action of the ACC and ESPN.
Perfect. Well, you straightened me out. That's what I needed to know, because I clearly was reading the kind of the general, as you said, definition. And I don't know if that's maybe specific to Florida or not, and how they use things, but I certainly understand public records laws, and there has to be something that an AG in any state can use to mandate somebody that they feel, is withholding a public record. And if that's it, then that's it. It didn't seem to jive for me. So
I have a follow-up to that.
Yeah.
Somewhat of a follow-up to that. Do you have time for another follow-up, Doug?
I do.
Okay. All right. So I like to give, like probably your favorite professors, I like to give you an opportunity for open response. Okay. So now this is kind of going to verge on the law and politics. And that's why it's kind of a follow-up to JY's question about AG Moody. So I know you're in the state of Georgia and you practice in the state of Georgia, but you're very plugged into the situation with Florida State and how they are connected within the state overall. I have said from the beginning that I expected the politicians in the state of Florida to get involved in this case in some way. And I thought it would have been sooner, whether the governor, the AG. So this has been kind of the AG. I kind of termed it as dipping her toes in the water. She she issues this writ. She sent a letter to her fellow attorneys general in the other states that are covered under the ACC, asking them, basically just kind of putting it out there and asking them if they want to join forces with her. So just kind of open response. Where do you see as far as the political situation in the state of Florida interacting with this case? Do you see any interaction moving forward? Could instead of just a writ like this, could the AG decide to go ahead and sue the ACC directly? Asking and the other AGs from the other states to do the same. Do you see that happening? Would she have a case or a leg to stand on? And do you see any further interaction by the politicians in the state of Florida getting involved in this case?
Well, let me start by saying I don't know AG Moody personally. I don't know her reputation, but looking at this cynically as a casual observer of politicians, I think it's perfectly reasonable to presume that there will be an escalated nature of their involvement. To your point, there was a trial balloon. It seemed to be well received by residents of the state of Florida. Not everybody in Florida is an FSU fan, but it is one of the two flagship universities for the state and certainly attracts a lot of attention. Politics for a large part of the population is boring and is uninteresting. So anything that creates engagement, just like we see on social media and our podcasts, that's all we want is, for me to hurl insults at you all so that you can clip them and share them on reels and talk about how you got to watch this episode. So engagement works for politicians as well. And that's all they want. They want a basis to have a tie to get whatever additional energy they can for their base, for their voters to go out and vote for them. And it is an election year. So I would be shocked if this is the end of this. As far as the merits of the suit and what's going to happen next, look, you can, in law school, we're famous for saying you can indict a ham sandwich. You literally can write up an indictment against a ham and cheese sandwich and say that it broke the law somehow. So could there be more litigation? Could there be more posturing? Absolutely. Is there merit in it? That depends on the state court judge that's listening to this and whether or not they're an FSU fan and how much they want to put into it. An actual suit for, I guess what she's threatening is, infringement on interstate commerce and things like that. I think that's a much further stretch, a much less likely proceeding to take place. But I do think you'll see, especially as we get to November, more saber rattling and more yelling and crowing about how much this is an injustice for our state university system. The lawsuit is not going to cost Florida State $500 million. The worst case scenario is Florida State remains in the ACC until 2036. How much will it cost to get out of that agreement? That's what we're fighting over.
Right.
The question is not, does Florida State have to pay the ACC $500 million? No, because we'll just stay in the conference and watch all of our national aspirations go get flushed down the drain. But we're not going to have to pay $500 million to the ACC.
Well, and I think that brings us full circle back to where I started this, and it's exactly that. And I started with it in their introductory paragraph. The two main questions. Number one, what happens to our media rights, as we talked about, the new count number one, after somebody leaves, and what is the actual withdrawal penalty? Is it this $140 million or not? I mean, that's the two things. And then FSU or Clemson or anybody can figure out, yep, that's the amount of money we're willing to pay to get the heck out of here because we got greener pastures and more money to make, potentially. I know we think they do in other conferences here on the mountain, but we don't know that for sure. But anyway, so bring that full circle here. Doug, I can't thank you enough for spending this much time with us again on the mountain. We really, really appreciate you coming on. And I want to kind of end it with you. Anything? I know we talked about your Twitter handle, but anything else you need to get out there so people can find where you're putting all your good information out at?
No, we're real excited to be here, and I enjoyed my time with you also. Trust me, I'm a big boy. If I didn't like you guys, I would have said no, but you all put on a great show, great production quality, and ask good questions. And I'm perfectly happy to stand here in the paint and take all the shots from the people who think that it should be otherwise. I've got thick skin, and that's why you should join me on Twitter or X at Rohan Law PC. That's where we put most of our thoughts and most of our impressions on what's happening with this litigation and what's happening with Clemson and some of this other stuff. It appears that litigation and collegiate football are now permanently, or at least for the next 10 years, likely going to be intertwined. So I'd be happy to learn about these issues and share my thoughts in a way that is easily digestible for our fans, for our friends, and for our viewers.
Fantastic. You do a great job.
And I just want to add, again, what we said at the beginning, we appreciate you coming on. And for all college football fans out there, we have kind of a broad audience. If you are a college sports or just a sports fan in general, you should be following at Doug. It's Rohan Law PC on Twitter. Actually, definitely follow him. I have your notifications on whenever you tweet. That's one of the better parts of my day. What's Doug talking about now? And you're commenting mostly on Florida State, but also just all of the things that are happening in college football, college athletics right now. It's a massive time of change. I saw you commenting on the recent the golf issue with the police and the body cams at the what is it, the PGA Open?
Championship.
PGA Championship. So if you're interested in really where sports and the law intersect, you cannot follow anybody better than Doug Rohan. So we love you. We love following you. We love having you on. We just appreciate your time. And all of our fans out there, you should be following Doug for sure on Twitter.
Steve and JY, y'all are too kind. I appreciate the chance to be here.
All right. Thanks a lot. Hey, thank you guys for watching. Make sure you give this episode a like, subscribe if you like our content. We'll see you guys next time on the Big Mountain.